good evening. Welcome. This is Hot Edition. We are live from our news up at Adesawe Kanda. Also live on Kesmi 107.1 in Tamale and beyond. We're live on W 93.5 in Wa and beyond. If you log on to our Facebook, 3FM 927 as well. We're live there right now and across all social media platforms. Your thoughts, views, comments, and opinions are welcome here on 3FM 927. This is Hot Edition. Coming up this evening here on Hot Edition on 3FM 92.7. We'll give you updates from the courts today. Seat vacancy controversy. Supreme Court rejects Speaker's application to set aside its earlier ruling. We have details for you and exactly how things played out in court today, plus some reactions here on Hot Edition on 3FM 92.7. Also on the matter of the vacant seats, the Speaker, according to the Attorney General, shouldn't have even been joined to the suit. What are the lawyers saying about this? We have got some reactions for you here on Hot Edition on 3FM 92.7. We have some updates as well from the Boko municipality with the latest clashes that has claimed almost 20 lives. We'll give you updates shortly there on Hot Edition on 3FM 92.7. And as always here on your Election Command Center, we'll give you updates of what's happening with the campaign trail of the various campaigns across the country, and also the latest in the world of business and sports. You're an integral part of the conversation. Let's hear from you. The hashtag we're using is Hot Edition on 3FM 927. Read out to you and to the rest of the world. But for now, Safwa Boaheng is here with a summary of the news.
Thank you, Alfred, and welcome to the news summary segment and to the details now. The Supreme Court has adjourned to November 11, 2024 for judgment in the substantive case regarding the 4 vacated parliamentary seats brought by Majority Leader Alexander Afenyo-Markin against Speaker of Parliament Alban Bagbin. Chief Justice Tokono highlighted the potential harm to constituents who would lose their parliamentary representation without the option of by-elections. She directed both parties to submit their statements of claims within 7 days to facilitate an expedited hearing of the substantive issues in the case. Also, the Supreme Court earlier today rejected the request for Justice Ernest Yaogawu to recuse himself from a 5-member panel handling a case on vacant parliamentary seats. Thaddeus Sori, representing the Speaker of Parliament, argued for Gawu's recusal due to his past association with the New Patriotic Party (NPP). The Supreme Court's final decision, however, allowed Justice Gawu to remain on the panel. Away from that, the Ghana Health Service is urging a return to COVID-era sanitation practices to contain a cholera outbreak in the Greater Accra region, with over 50 cases and 2 deaths reported. Director General of the Ghana Health Service, Dr. Patrick Kuma Abuaje, noted a reduction in the critical cases in the hardest hit district of Adan East. Local authorities are intensifying efforts to address unsanitary conditions fueling the spread. NDC presidential candidate John Dramani Mahama has stated that Vice President Dr. Mahmoud Bawumia does not require a debate to respond to the 5 questions Mahama posed to him. Mahama's comments came amidst calls for a debate between the two, but he emphasized that this or his questions could be addressed without a formal debate setting. Now, before we go, 4 people have died after their vehicle veered off the road and into the Uabi River near Daba in the Chima Mwabija North District of the Ashanti region. The accident occurred on Tuesday, October 29. A search party is currently looking for a missing 5-year-old girl, Doreen Yassan. District Presiding Member Francis Bobby Ansa described the incident as pathetic while speaking on the Ghana Koma Morning Show. And this brings us to the end of our news summary segment. And over to you, Alfred.
Thank you very much for this. And so for buying there with a summary of the news. So live here on Hot Edition on 3FM 92.7, also on Kesmi 107.1 in Tamale and beyond. We're live on W 93.5 in Wa and beyond. Let's get into the details of the stories right now. The Supreme Court has dismissed an application by the Speaker of Parliament, Right Honorable Alban Akrofi Ocansey, who attempted to overturn the court's ruling that suspended his declaration of 4 parliamentary seats vacant. This follows as the initial suit filed by the Efutu Member of Parliament, Alexander Afenyomakin, challenging the Speaker's declaration. The Speaker's lawyer, Thaddeus Sori, contended that the Supreme Court lacked jurisdiction in this particular case. Let's go to the Supreme Court earlier today and give an update on what happened. This is what Thaddeus Sori said in his submission.
And we're saying also that even if it were curable, which it is not, the court's jurisdiction, substantive jurisdiction, to entertain the matter as a whole was not properly invoked. Was not properly invoked because the court lacked jurisdiction to entertain the matter as a matter, the purpose of which is to determine whether or not the seat of a member of parliament is vacant. That matter belongs exclusively to the jurisdiction of the High Court. And this court has affirmed that consistently, not deviated in one, that if it has to do with the membership of a person in parliament, that belongs in the realm of the High Court, not this court.
Well, however, after hearing arguments from all parties, including the Attorney General, Godfrey Yeboah-Dame, the Supreme Court maintained that its earlier ruling was appropriate, stating that the Speaker's appeal was without merit. I want to take a listen to exactly what the Chief Justice, who in fact led this particular panel to deliver this ruling earlier today, indicated and the reasons why they came to that conclusion.
The Speaker of Parliament. It is therefore disingenuous and wrong, including being an act of disinformation, for the argument to be presented that the jurisdiction of the Supreme Court could never be invoked to determine a constitutional interpretation because of the High Court's jurisdiction to hear and determine disputes on elections and vacation of seats of members of parliament under Article 99. Our clear view is that Article 99 gives the jurisdiction to hear cases involving questions on validity of election or vacation of seats of a member of parliament and the speaker. It does not in any way take away the jurisdiction of the Supreme Court to interpret and enforce any provision of the Constitution, including Article 99 itself.
That's the Chief Justice there, Gertrude Tokono. Let's go right now onto the telephone. My colleague and our lead court correspondent, legal affairs correspondent, that's Joseph Akable, is connecting with us right now from the premises of the Supreme Court. Joseph, now we do know what the conclusion of the Supreme Court's justices were on this matter, but you've been speaking to some of these persons of interest in this case. What have they been telling you?
So first, the Attorney General, he expressed satisfaction with the decision of the court today with respect to the request by the Speaker of Parliament, which was dismissed, then also the decision to defer the ruling on concerns that were raised about portions of the affidavits which have been filed by the Speaker of Parliament. The court had also dealt with the issue on whether a judge should recuse himself or not. The AG also expressed satisfaction with that and also provided some additional details about why he had raised the issues about the Speaker of Parliament being represented by Thaddeus Sori, a legal practitioner.
See, on the matter of the Speaker misconstruing the Chief Justice's circular, I want us to hear exactly the explanation that the Chief Justice gave to this and what the reaction was in the courtroom with regard to this particular point. Let's take a listen to the Chief Justice.
The consideration of these exceptional circumstances was clearly spelled out in the ruling of 18th October 2024. So it is surprising that the applicant should urge that the discretion of the Supreme Court was exercised in breach of Article 296. So why did the Supreme Court grant orders after hearing this application ex parte or without notice to the Speaker of Parliament? Once again, the ruling stated the reason clearly. The official records of Parliament for 17th October 2024 was placed before the Supreme Court as an exhibit The record showed that the processes of court had been served through the legal department of Parliament, and this had been brought to the notice of the Speaker. He bantered extensively on this information with the plaintiff on the floor of Parliament. And the Speaker's only reason for choosing to quarrel with the summons from the Supreme Court, an application for injunction to restrain him from ruling on a matter premised on interpretation of Article 97(1)(g), was that as Speaker, he was only supposed to be served with court processes on Monday. This is an unfortunate interpretation of the first column of the circular referred to, because this circular provides for the Speaker of Parliament to be served personally on Mondays and through the legal department of Parliament on any day.
Now, Joseph, this particular circular had been a matter of reference, at least over the past 2 weeks, that this matter has been playing out. With the Chief Justice's position and also explanation to the details of this circular, how was that received in court?
I mean, what we do know for a fact is that lawyers for the Speaker of Parliament are not in agreement with this particular position that was advanced by the Chief Justice. And we know this because even on his feet, Thaddeus Sory, during the initial argument, you recall, when the case commenced, the Attorney General had asked for parts of the affidavit to be struck out. The parts of the Speaker's, the affidavit filed on behalf of the Speaker, which makes the point that the Chief Justice was aware of the unconstitutional service of the process on the Speaker of Parliament. Now, in the course of the legal argument, Thaddeus Sory did insist that that was a correct position because the Speaker of Parliament had engaged with the Chief Justice and reached that agreement on that being service. And so the Chief Justice at that point drew the attention of the Attorney General to address the legal effects of that circular. And the Attorney General replied by reading the constitutional provision to say that, look, the constitutional provision that talks about the fact that the Member of Parliament or the Speaker cannot be served when they are going to Parliament or from Parliament or performing parliamentary duties, it does not have any Monday or Tuesday attached to it. So he doesn't understand why it's being interpreted to mean that what has been agreed administratively has the force of law. And so he insisted that the Constitution is the supreme law, and once the Constitution has not placed any such restriction, whatever administrative decision has been taken is not one that is born or supported by law. But Thaddeus Sory did shoot back and make the point that, well, the Speaker was simply following what had been agreed with the Chief Justice. But with the court ruling, at least going forward, at least there's some direction or clarity on what should take place. But what we know for a fact is that the Speaker's side are not impressed with this particular conclusion that the court has reached on this particular matter.
On the matter of whether the Speaker, fantastic point there, Joseph, and the matter of whether the Speaker was properly served or not, it took quite some part of the debate as we saw it. And just want to take a listen to this and how this particular issue ended.
But whatever interpretation of the circular that the Speaker chose to put on how he was to be served, the Supreme Court is satisfied that the Speaker was well served with notice of the action that had been started on 15th October 2024 and seeking the correct interpretation of Article 97(1)(g) of the Constitution. He was well served before he delivered his ruling on 17th October 2024 that would lead to the exceptional circumstances enumerated herein. And the Supreme Court carries the constitutional obligation to give the correct interpretation of Article 97(1)(g) for its enforcement, if need be, by the High Court or any person that the interpretation comes to. Hence, the scope of the orders made to stay as enforcement of the Speaker's interpretation of Article 97(1)(g). We have considered the objection to the procedure used to serve the Speaker because of the administrative circular of the Chief Justice in 2021 and 2024. We are satisfied that administrative procedures cannot override the potency of legality, and every procedure used by the Supreme Court to serve the processes on the Speaker of Parliament were actually in conformity with law and the circulars issued by the Chief Justices in 2021 and 2024.
And Joseph, I recall that prior to today, the matter of whether it was served procedurally or otherwise was on premise on the fact that the summons was left on the table of the legal department of Parliament. Was that matter settled with this?
Yes, it was a matter that had been in contention because in the ruling on the main case, even in Parliament, if you recall the discussion, Alexander Afenyomarkin, the MP for Efutu and leader of the MPP caucus, had attempted to make those documents available to the table office. And so the service has been at the heart of this particular matter. Again, the Chief Justice, in part of the clip that we played a short while ago, did indicate that the records that were made available to the court did show that the Speaker's attention had knowledge of the fact that there was a pending case. And he made the point that even when the matter was raised about the fact that there was a pending matter, there was an ensuing debate on what interpretation ought to be attached. And the point the court makes is that once they were satisfied that the Speaker had knowledge of it, he took the view that it was only appropriate that the matter should be referred to the Supreme Court for interpretation. In fact, the Chief Justice, in a very detailed decision which she delivered on dismissing the Speaker's request for the court to set aside its decision, explained that even in cases such as this, that some have argued should go to the High Court, he says, in the manner of the dispute, particularly because the lawyers on all sides in the case have a different meaning of Article 97, it only meant that even if the matter had gone to the High Court, even the High Court would not have proceeded with the matter and would have been bound to refer the matter to the Supreme Court. And so in the same vein, she took the view that the Speaker had knowledge of the matter, there was appropriate service, hence, as a result of that knowledge, and proceeded to say that it was satisfied that that had been complied with.
So, Joseph, what's going to be happening on November 11th?
There are two things. Initially, the indication that came from the panel suggested that the court will be delivering its judgment on that particular day. That was the main direction that the court was leaning towards. But the Attorney General did point out that they would want to have an opportunity to address the court as well. But the court responded that, yes, they will hear them, and then they will take an adjournment and deliver the ruling, hopefully on that day as well. And so it's very much likely that on November 11th, that judgment will be delivered on the substantive case. And the substantive case is an explanation of the Article 97, which has been in contention now. When does it apply? When does it kick in? When will a member of Parliament be said to have vacated his seat? Will it be said that he has been deemed to vacate his seat when he fails to contest an election which will be taking place to constitute the next Parliament and not the current Parliament? Or will it only take place when he crosses over from one caucus to the other and still wants to remain in Parliament? All those are the substantive questions in this particular matter. The Supreme Court intends to settle and bring some clarity to this unending dispute.
Joseph Akable, appreciate you for this. Thank you so much. Joseph Akable is a senior law court correspondent, giving us updates on what's happening there at the Supreme Court. So if you did not follow with what we have just talked about, it gives you a fair idea of how things played out at the Supreme Court today. It's live here on Hot Edition on 3FM 92.7, also on Kesmi 107.1 in Tamale and beyond. We're live on W 93.5 in Y and beyond. If you're just joining us, the Supreme Court has dismissed an application by the Speaker of Parliament, Right Honorable Alban Suman Akinfo Bagmin, who sought to overturn the court's ruling that suspended his declaration of the 4 parliamentary seats vacant. This follows that initial suit filed by a Efutu Member of Parliament, Alexander Akrofi, challenging the Speaker's declaration. The Speaker's legal team argued that the Supreme Court lacked jurisdiction in this matter, amongst other grounds canvassed in court. Martin Pebble is private legal practitioner. He's been following this case quite closely. He's joining us on the telephone. Counsel, good evening. Thank you for joining us here on Hot Edition.
Yeah, good evening, Mr. Ocansey.
On the matter of whether or not the Supreme Court has jurisdiction to hear this matter, the Chief Justice was quite clear that indeed they have jurisdiction to hear this matter, and rightly so they went ahead to hear this particular case. And I want you to take a listen to her, and I'll get your reactions to this position that she took in her ruling today.
It is therefore disingenuous and wrong, including being an act of disinformation, for the argument to be presented that the jurisdiction of the Supreme Court could never be invoked to determine a constitutional interpretation because of the High Court's jurisdiction to hear and determine disputes on elections and vacation of seats of members of Parliament under Article 99. Our clear view is that Article 99 gives the jurisdiction to hear cases involving questions on validity of election or vacation of seats of a member of Parliament and the Speaker. It does not in any way take away the jurisdiction of the Supreme Court to interpret and enforce any provision of the Constitution, including Article 99 itself.
Well, Counsel, that's her verdict on the argument of whether or not the Supreme Court had jurisdiction to hear this particular case.
Yeah. You see, when it comes to, so I've been explaining that for the jurisdictional matter, I knew that the average lawyer knows. You see, there is the one that you believe that the court may not have jurisdiction, but there is the one that if somebody wants to defend that position, it's very easy to defend. And so I'm not surprised that the Supreme Court says it has jurisdiction. But you see, don't say there's no jurisdiction. It's because the provision appears very, very clear to us, right? It appears very clear to many people that, Isiama was an independent, and now he has filed his papers with EC, contesting on the ticket of the MPP. What is ambiguous about it? Mamle Morrison and Co, they all filed. So what's ambiguous about it? So if you look at it, I understand those who are saying there's no jurisdiction. But I've also listened, but I always knew that that's the way law is. I keep saying that if you want to understand how law works, there are different schools of thought, like the way human beings we are. You will see, take a common example from religion. You see the tithe, paying tithe as Christians. You hear the way different priests, different pastors have different jurisprudence on tithe. Some will say it's not compulsory. Others too, some churches is compulsory. That's the same way the law works. We have different perspectives. So finally, it depends on the one who has the power. It's the Supreme Court judge. So the rest of us may be explaining that no, it's wrong because we have different perspectives, but we are not the people making the final call. So the thing is that all these opinions we are offering, everybody is right because we see it from different angles. That's the thing about law. Yes, no, there's no argument that's wrong because I knew it. I knew that this jurisdiction thing is the easiest thing for them to answer because they will just say that, listen, from the way the thing is, there's a controversy. This person says, the provision is not clear. The other one, so this person is saying A, the other one is saying B. So it was the easiest. This jurisdictional matter, it was the easiest. That's how come you see so far in my public commentary, I've not been pressing the jurisdictional matter. The one I've been pressing most is that, listen, even when Safisi Abedu himself went to the court, because Speaker had not been served to come and argue on the stay of execution, he did the honorable thing at the bar, which is that when you go ex parte, that's to say if you go alone, you ask for 10 days. 10 days. You don't ask till the end of the case. So you see that one, if you raise this in every lawyer you talk to, you are going to get at least more than 80% say yes, that one there. So you see that in my commentary, that's the one I've been pressing and saying, no, the court didn't do well. But Speaker is in Ghana, so they should have just done it for 10 days, or even before even the 10 days, they should have taken steps to serve Speaker, blah, blah, blah. Those ones are easy to defend. That one, the court cannot have a proper answer. They were struggling. Even today, can you imagine that the one, Mr. Ocansey, you showed the judicial circular, which clearly states that the Speaker should be served only on Monday. Today in the court, we heard them say, that's not what the circular says. That the circular says they can serve every day. So I read it again. I didn't see the every day. You see, so my point is that in law, the points may be many, but I choose to use the ones that you will get very few people disagreeing. And so if you see the person disagree, everybody will know that this one there is not law the person is arguing. He's arguing something else. But the jurisdiction there is something that if they want to defend it, they can defend. And that's why they've defended easily. Yes.
I see, and it's a very important point you make about the issues about the expedited hearing, the reasons that they give. In fact, when under normal circumstances you would have an ex parte motion actually having a 10-day period to last. This is what the Chief Justice said in explaining why the courts decided to take a different route.
The Constitution enjoins the Supreme Court to make orders that are appropriate for giving effect or enabling effect to be given to its final declarations on the correct meaning of a constitutional provision. And the Constitution is so serious about ensuring the obedience of such orders that it creates the offense of high crime for failure to obey such orders in Article 2.4. Not even the President and Vice President are exempt from obeying the orders of the Supreme Court when they are made to give effect to its duty to prevent a violation of the Constitution. Because of the irreparable harm to the constituencies made up of hundreds of thousands of Ghanaians who would have lost their MPs without the option of a by-election, and the irreparable harm to the MPs who would have lost their seats in Parliament in these last few weeks to the 7th December elections, if the meaning put on Article 97(1)(g) by the Speaker was enforced without a clear determination of the disputes around it, this court found it expedient to compel the parties to allow an early hearing rather than make an order that would last only 10 days. This is the reason for the Supreme Court's orders abridging the 14 days allowed for defending a constitutional action through a statement of case and directing the parties to file their respective statements of cases within 7 days and present the issues for resolution immediately thereafter. If the parties had complied with the court's orders, this would have taken all of the 10 days the applicant urges an ex parte order ought to last.
Counsel, so that's the explanation she gives to that point that you just made.
Well, I'm not with the court on this matter. That explanation, to be honest, I'm not with the court. I'm not persuaded. As I told you, see, so can't say this thing. If you want to understand this decision, just remember that it has boiled down to who has power, and the Supreme Court is telling us they have power, but not because every lawyer will agree with what they said. No, I told you the training is saying that it's the same law school we all go to. Okay. Well, so when you finish law school today, like the way Dennis Widam has graduated, last week, 11th of April, October, right?
Yes.
So that's it. So let's use Dennis as...
Hello? Hello, Counsel. We'll try to raise Martin Pebo back on the telephone. Unfortunately, we lost him when he was making a very, very important point there. We'll raise him back on the telephone to get a bit more into this matter. But if you're just joining us here on Hot Edition on 3FM 92.7, we're also live on Kesmi 107.1 in Tamale and beyond, and also on W93.5 in Y and beyond. The Supreme Court has dismissed an application by the Speaker of Parliament, Right Honorable Alban Suman Akinfo Bagwin, who sought to overturn the court ruling that suspended his declaration of 4 parliamentary seats as vacant. This follows an initial suit filed by the Futu Member of Parliament, Alexander Bejomakin, challenging the Speaker's declaration. Now, let's go back onto the telephone now. And Lawyer Martin Pebo is back. I lost you when you were making Dennis Widam's example.
So where did I rate? Dennis as a High Court judge, or he was still in the magistrate?
To the extent that I lost you when you said he had graduated. So you just at the beginning.
Oh, okay. So I said Dennis graduated on the 11th of October.
Yes.
Okay. This year. Now, straight away, Dennis, as you find, your colleague, he qualifies to be a magistrate. So if Dennis doesn't want to come to court as a practicing lawyer, anytime the judiciary opens the window, he can apply that he wants to be a magistrate. So Dennis, you find today, tomorrow he can be a magistrate in any court. And I'm saying 10 years on, when he has worked as a magistrate, even before the 10 years, after 5 years, he can go to the next bigger court called Circuit Court. And then another 5 years plus the 5 when he went to Circuit Court, he can go to the High Court if there are vacancies. Then 2 years more, if there are vacancies and he has the right connections, he can go to the Court of Appeal. Now, after Court of Appeal, there is the point I'm making. You don't write exams to go to the Supreme Court. It's the same lawyer you are. I think so. If Benny, he's in the Court of Appeal, Supreme Court, there are vacancies. He can try, but that one is harder. It's about your relationship with the president, etc. So the things, the decisions, if you want to understand plainly, a lot goes into affiliations and the rest. Because after the decision, we can talk ourselves course. You see that we come from different persuasions. So the president sits down and watches and sees people who will be persuaded by his arguments when there are crises like this, etc. That is what goes into selection of the judges. So you keep asking, what's your opinion on this? And then we are all divided. We are divided because it's one text, but we are coming from different angles, different perspectives. So a president will usually choose the people that he sees that the way it's is, and tomorrow when there's trouble, this is likely to rule how me, Akufo-Addo, would have ruled. So those are the people he will choose. And so that is how the law is made. So it's the president's line. There's nothing more, because look, if you don't explain it this way, people will just be going and will be hitting ourselves all over. And no, that's just it. It's one text. So it's clear to you that me, Tebu, if I was a Supreme Court judge, this matter when afternoon brought it, I would have thrown it out straight and said, go and serve Speaker. Speaker is in Ghana. You know, I said it the Saturday before last Saturday.
Right.
You give steps. Go and serve Speaker. The Speaker will not accept it. So that was a Friday. Throw them out, but not 100%. They throw out means I'll not grant you the thing today, the stay of execution. But take the same papers and then make copies, extra copies, because they didn't make copies for Speaker. So they just ran copies and then stamp them certified. Let the bailiff go and find Speaker Friday afternoon, Saturday. If Saturday by 8 p.m. they don't find Speaker, I'm making another order. Blast it in the newspapers and other media. So that Monday, 21st, then they would have sat, because Parliament was going to sit on 22nd. So no harm will be done. So you see, that's my thought. But Akufo-Addo doesn't like this kind of thought. So Tebu will not get to the Supreme Court. You won't get there because he doesn't want this one. He wants the one that, MPP is in danger. So let me find people who will be sympathetic. Yes, that's how the thing is. If we are speaking plainly, because if you don't do that, this thing will be running around trying to give all manner of explanations. My brother, it's simple. We have different inclinations, different perspectives. So the one who gets chosen to be the judge, that person's perspective is what will become the law. But it's not that the other people are wrong. That's not it.
Now, but and even gauging public sentiments right now, the Supreme Court's ruling on this speaker's application was widely predicted by the public. In fact, a number of the polls we have done said the respondents said they were not surprised. I mean, how does that hurt or impact the optics for the courts, the Supreme Court itself?
Yeah, so the court will sink deeper and deeper. Yes, so the trust is gone. Did you see the letter Senor Hoti wrote to the CJ today? Open letter where they were quoting that the public confidence in the judiciary, the trust is at 35%. But the last Afro barometer, Senor Hoti's quote, okay, we can verify it. But the last one, the 2012 measurement, the Afro barometer 2012, the public trust in the judiciary was at 65. But this last one, 2024, is at 35%. That's almost like half of it is gone. So it's part of it. It looks like it will get worse before it gets better. So what we are doing now, you see, you say public confidence, the public sentiment, people predicted it. So through this talking, that's one thing is good. Let more people talk. As we talk and talk, we are refining the arguments and then naming and shaming ourselves and then trying to do better. It has to get better. Listen, Kwame Nkrumah's Ghana is not going to go up in flames. No, we'll talk and then hopefully, who knows? It should get better because I'm optimistic. If that's not it, if I wasn't hopeful that Ghana would get better, I would not be here. I would have fled over 2002. Yeah, I would have fled long ago. But we saw America and chose to live here. I still have mates who went and never came. But we said, no, this is our home. Let's stay here.
Indeed.
So as long as I live here, I'm hopeful. Let's keep talking. Hopefully, it will get better. Yeah, we can only hope because we can't give up. No. As long as there is life, as long as we have energy, let's keep fighting.
And Counsel, quickly, I know you have to leave us, but how do you respond to the position espoused by the Attorney General, for instance, in court earlier today, that there is no better mechanism in seeking clarity of the controversy in the application of the Constitution than seeking interpretation of the said provision that has caused the controversy at the Supreme Court?
No, of course, I don't agree, because that thing is clear. Let's say, do you have the provision that you can read there? It says if you are an independent and you join a political party, then you lose a seat. So so far, the argument people have been saying is that it should be a future thing, not now. So I just like to, so we are talking about 97 clause 1. So those who are saying that this thing is not clear, how is it not clear? The thing is very, very clear. So if you were, I still come back to this point that it's just a question of different opinions. We will never agree because we are different perspectives to the law, right? So I don't agree with the Attorney General, because for me, when I read 97, it's clear. Look, I've opened to 97. 97, 1 each. I want to start with Isiama. It's easier. It says, H says, okay, so I'll start 1. A member of parliament shall vacate his seat in parliament. Then H, if he was elected a member of parliament as an independent candidate and joins a political party, if he was elected, I'm repeating, a member of parliament as an independent candidate and joins a political party. So the simple one question we are just asking is, Mr. Ocansey, as I'm talking to you now, is it not a fact that Esiama's papers at the EC show that he's an MPP candidate? Is that not the case?
It is indeed.
Yeah, so what again are we talking about? He has not joined MPP. And so how did the MPP put him up as a candidate? Well, what is, go to Supreme Court and interpret this. What is this about? Some are saying, no, it's not for this parliament. It will only take effect in the next parliament. So how sure are you that Esiama will win? How? That if he joins another a political party, it's not for this current parliament, for a future parliament. So is it that after Esiama has won the elections, then will now declare his seat vacant? I don't even understand. Yeah, those who are, I don't know if Mr. Ocansey, maybe you understand that argument better. If we are saying that Esiama being MPP now, if we are saying that it doesn't affect this current parliament, but it's to affect the future parliament. So the question I'm asking is that, are we saying that, let's say, if Esiama wins in this December election, then because it's going to affect the future parliament, then it means he should rather resign, he will forfeit the seat in 2025. Is that what we are saying?
Essentially not. I mean...
So it's to make the point that what the Attorney General is saying is that we should go to Supreme Court for interpretation. No? There is nothing to interpret, but when the law is weak, that is what you get. People will exploit it because they just know there's a loophole. But what is interpretation about this? Esiama's papers at the EC saying he's MPP today. Meanwhile, this current parliament is still ongoing. So he's no longer an independent. He has joined MPP. Esiama's papers saying he's MPP. How can you say, no, you don't agree? This needs interpretation. I told you, if we are not careful, we'll talk and talk and talk. Oh, yeah. Sorry. Anyway.
Counsel, and I do appreciate your analysis of this matter and your expected legal explanation to this. Thank you so much.
You're welcome.
Martin Pebo is private legal practitioner, one of the foremost constitutional lawyers that we have in this country, and a human rights lawyer as well. And in fact, a number of you have been reacting to this latest development at the Supreme Court, and reference is made of the Speaker. Just that point that Martin Pebo ended with, the Speaker of Parliament in his ruling 2 weeks ago did indicate that if Article 97 1G and H were to apply only to future parliaments, they would have been rendered superfluous. But by the time the next parliament is constituted, any member of parliament who was defected or switched political allegiance during the current parliament will no longer be in violation of this provision. They will start the next session aligned with their new party or as an independent. Thus, there will be no defection and the violation will be wiped clean. So that's the position of the Speaker of Parliament on this particular argument. But it's some 17 minutes to the top of the hour, 6 p.m. here on Hot Edition on 3FM 92.7. We're live on Kesmi 107.1 in Tamale and beyond, and also on W 93.5 in Wa and beyond. Keep your thoughts coming through at 3FM 927, read out to you and to the rest of the world.
We have considered the objection to the procedure used to serve the Speaker because of the administrative circular of the Chief Justice in 2021 and 2024. We are satisfied that administrative procedures cannot override the potency of legality, and every procedure used by the Supreme Court to serve the processes on the Speaker of Parliament were actually in conformity with law and the circulars issued by the Chief Justices in 2021 and 2024. We are satisfied that administrative procedures cannot override the potency of legality, and every procedure used by the Supreme Court to serve the processes on the Speaker of Parliament were actually in conformity with law.
Well, earlier there was a matter of one of the judges who was actually empaneled to sit on this matter, and the Speaker's lawyer, Tadio Sori, asked that this particular judge recuses himself, and I'm going to get into that shortly, and how the Supreme Court, as it were, ruled on this matter and the details that was given earlier today. The Supreme Court dismissed that objection from the Speaker of Parliament's legal team to Justice Yao Gao's presence on the panel in the case challenging the Speaker's ruling on the 4 vacant parliamentary seats, calling the objection misconceived. Now, the Chief Justice Gertrude Tukono, leading the bench, clarified that the matter at hand is a constitutional issue, not a political party case, dismissing the suggestion that Justice Gao's alleged affiliation with the New Patriotic Party could compromise his impartiality. Let's first take a listen to the lawyer for the Speaker of Parliament, Tadio Sori, on this matter.
Well, we're saying also that even if it were curable, which it is not, the court's jurisdiction, substantive jurisdiction, to entertain the matter as a whole was not properly invoked. Was not properly invoked because the court lacked jurisdiction to entertain the matter as a matter, the purpose of which is to determine whether or not the seat of a member of Parliament is vacant. That matter belongs exclusively to the jurisdiction of the High Court. And this court has affirmed that consistently, not deviated in one, that if it has to do with the membership of a person in Parliament, that belongs in the realm of the High Court, not this court.
Tadio Sori there, but on the matter of the Supreme Court's jurisdiction and hearing this case, Mr. Kweku Asari, who is a former director of the Ghana School of Law, has maintained consistently that, in his view, and per the dictates of the law, the Supreme Court did not or does not have the jurisdiction to hear this particular case.
An attempt was made to set the Speaker through the legal department. That is wrong. You can either serve the Speaker himself or normally the clerk of Parliament. Never the legal department. That's the first point. The second point is that nothing has been said so far about whether or not the Attorney General, the second respondent, was served. Now, the usual practice is that where an application is brought ex parte and the respondents are not before the court will either have to adjourn or grant the application for
a maximum number of 10 days and direct the applicants to bring the respondents by notice. So the applicant, the Honorable Afenyo Martin, would have taken steps to serve the Speaker and the Attorney General properly. That was not done. And therefore, the procedural lapses render the Supreme Court proceedings a nullity. Now, a more fundamental constitutional point arises. Can the Supreme Court impugn a decision of Parliament that was taken in the usual course of parliamentary business? The answer is no. The Supreme Court has no such power. What the Supreme Court did yesterday amounted to provocation of Parliament. It provoked Parliament. Now, Parliament under Article 122 has contempt power. Just as the Superior Court of Judicature also has contempt powers. Now, what the 5 justices did yesterday amounted to contempt of court. And Parliament can hold them before the court. So what the Supreme Court did yesterday was needless. It has created a situation of constitutional lawlessness.
As a former director of the Ghana School of Law, Kwekwansa Sari, and there's also private legal practitioner, let's stay a bit on this matter because a number of you have been reacting to it as well, and thankfully we have some different perspectives also to this. Ivan Mensah Dadzi is joining us on the telephone right now. He's a private legal practitioner as well, has been following this quite closely. Counsel, good evening. Thank you very much for joining us here on Hot Edition.
Good evening, there.
Great. Now, this is the conclusion of the Supreme Court earlier today, that the Speaker's application cannot hold. They have set November 11th to hear the Speaker's lawyers and, in fact, hear this particular case and later deliver a ruling. With how things played out today, did the question of whether or not the Supreme Court has a jurisdiction to hear this case duly answered for you?
To the best of my understanding, anyway, first of all, good evening to your listeners. I followed closely proceedings of today, and I must say that in as much as some development may not have actually sat well with me, as far as procedural matters are concerned, I should think that to a large extent, the question of whether or not the Supreme Court had jurisdiction to entertain this matter was answered by the court.
And why is that? Because there are some lawyers who have argued otherwise, to the extent that, I mean, it was quite clear, based on the dictates of Article 99, depending on which side of the law you want to argue, you will still have grounds to side with the courts or criticize the court's position on whether they have jurisdiction or not. That's the position of Martin Kpebu when we just spoke to him recently.
Yeah, that is right. And we are entitled to understanding of the article. But my understanding, based on the proceedings of today, is that the application by the Speaker's lawyer was to vacate the order on the basis that it was a nullity, because the Supreme Court in the first instance had no jurisdiction to entertain the writ. Now, the simple and straightforward response provided by the Supreme Court was that in as much as the Speaker emits in the ruling sometime last 2 weeks, actually interpreted the Constitution, then another person's rival interpretation of the Constitution actually brings into the fore the issue about which of the constitutional interpretations is actually right. And we all know that in the matter of interpretation of the Constitution, the only forum that has jurisdiction to do that is the Supreme Court. That was the justification provided by the Supreme Court. The question of whether or not indeed there was a question which actually arose relating to interpretation of the Constitution in the ruling of the Speaker. That is another question altogether. My best opinion is that what the Speaker did, in as much as there had been precedents, and in as much as the provision of the Constitution was very clear, was mere application of the law. However, the plaintiffs actually went to court that their understanding of the provision was different from what had been applied by the Speaker. In other words, there had been two rival interpretations in their opinion. And that is why the Supreme Court, in its decision today, indicated that it had jurisdiction so far as there were two rival interpretations of the relevant provisions of the Constitution.
In the end, what's happened now to some is rather continuously bringing the courts in to settle political matters. As an officer of the court, do you share in the same concern that the likes of Dr. Rashid Rahman, who's a governance expert, raises the question that for as long as we continuously invite the courts into political matters, it is overly exposing the courts to politics?
Well, I should say that is a very interesting opinion. That my position is simple. That so long as the question of which version of our understanding of the Constitution arises, then the right forum to deal with it will be the Supreme Court. However, we would all agree that much of what is happening today is actually politics. And when it comes to politics, and I've made this point a number of times, that being it what we have all witnessed, and considering the fact that the underlying issue is politics, properly so called, perhaps the solution does not lie in law. The solution, in my opinion, may lie in diplomacy. And that, I believe sincerely, that the leadership of Parliament have actually failed in that regard. Because what is happening now, and especially considering the next day for the hearing of the case itself, that will take us closer to election day and closer to the original date for Parliament to rise. And so if Parliament should be reconvened next week, what business can they do with the time left on their hands? We have already lost precious time because of this. Unfortunately for us, our Supreme Court does not have the power to say that even though this is a question relating to interpretation of the Constitution, we are not interested and we would not sit on it. And as long as this continues to be the case, the court will forever be invited to actually go into political matters, cloaked in legalities.
You've made a fantastic point in there, and Counsel, I do appreciate your time on this matter, and also the recommendation that you make about the solution to this matter being more of a diplomatic approach, not a legal approach. We'll see how the coming days will look like on this. Thank you so much.
I'm grateful, my brother.
Ivan Mensah Dadzi is private legal practitioner with his thoughts on this matter. Number of your messages coming through here on Hot Edition on 3FM 92.7, also on Kesme 107.1 in Tamale and beyond. We're live on W 93.5 in Wa and beyond. Nanaya sending us a message from Kaswa, says, good evening. It says that I'm one of many people who is not surprised about the outcome of the Supreme Court ruling today. I just hope that the rule of law will still play out as well when the tables turn, you say. Thank you. Dr. Kwame Asante says, good evening. Listening to Martin Bebo explain the law soothes the ears. now we know that depending on which side of the pendulum this legal battle swings, the explanation to the law would always seek to favor one position or the other. In the end, what is the solution that the law is bringing? You'll say. Sami says, good evening. Will this legal battle end at all? From what I'm seeing, it's going to go on until December 7, and who then loses or wins? You say. Thank you very much for your messages, and quite a number of them. We'll read them after this quick break. Stay with us here on Hot Edition on 3FM 92.7, and Bismarck Osa is standing by with the latest in the world of business, after which we'll have the sports news. We're back with Campaign Trail.
Today, we thank you very much for your invaluable service to this great company, and we wish you well on your retirement. Cheers.
Thank you.
Happy retirement, Lay.
Thank you very much.
So are you staying or you are going back to Ghana?
I'm going back home, of course.
Wow. You really built?
I've got a home at Lakeside Estate.
Really?
Lakeside Hills is a dream come true, a community designed for all stages of life. Whether you're a growing family needing more space, a young professional looking for convenience, or someone seeking a peaceful retirement, Lakeside Hills has it all. With 2, 3, and 4 bedroom homes, there's something for everyone.
That's impressive. Exactly what I'm looking for. I have to start saving towards this.
See you back home.
Lakeside Hills, it's not just a place to live, it's a place to thrive.
Hello, good evening and welcome to the business segment on Hot Edition with me, Bismarck Ausa. Coming up tonight, Institute of Statistical, Social and Economic Research, ISE, opposes calls for outright ban on small-scale mining, underscoring its over 50% contribution to foreign exchange earnings. We'll hear from Director of the Institute, Professor Peter Korte. Thanks for your company. Now to the detail. Director of the Institute of Statistical, Social and Economic Research, ISE, Professor Peter Korte, has stated that banning small-scale mining in Ghana is not feasible, despite its adverse effects on water bodies and forest reserves. According to him, the mining sector accounts for over 50% of Ghana's total foreign earnings, underscoring its importance to the country's socio-economic development. He, however, recommends that policymakers focus on limiting mining activities in sensitive areas such as near water bodies and protected forests.
Food accounts for a greater proportion of our export earnings. The challenge is that because of the export retention scheme, a good proportion of the forex is retained outside the country, so it doesn't flow in to support our foreign exchange. We also caution that given what we are finding with mining, the illegal mining, the environmental effects, we have to promote responsible mining, ban all mining in forest reserves, ban and enforce all mining on river bodies, and regulate the small-scale mining sector. We cannot ban mining in total because it's an important part of our economy. And given that even cocoa, one of the major export earnings, is seeing over 12% decline, we cannot afford to ban mining, but rather promote responsible mining. If we manage the environment very well, our cocoa production would also improve, our food basket would also improve, and will not pollute or poison our food sources. So that for us is key.
And that was Director of the Institute of Statistical, Social and Economic Research, ISE, Professor Peter Korte, opposing outright ban on small-scale mining, underscoring its contribution of over 50% to Ghana's total foreign earnings. Moving on, the Deputy Minister of Energy, John Sani, has revealed that Ghanaian companies in the upstream petroleum sector generated $2.9 billion in revenue from 2014 to 2020 through local content initiatives, with projections set to exceed this figure. He noted that these gains are enhancing the sector's financial landscape, boosting employment, and increasing Ghanaian participation in the industry. This growth is expected to create more opportunities for local businesses and skilled professionals within the sector.
The passage of the Petroleum Local Content and Local Participation Regulation 2013 LI 2204 ensured that Ghanaians and indigenous Ghanaians companies, ICGs, participate in the petroleum upstream activities through the granting of petroleum licenses, the employment of personnel, the procurement of materials, goods, and services. Through local content and local participation value of service for the period of 2014 to 2020, a transactional value of USD 2.9 billion was realized from the operations of the indigenous Ghanaian companies in the upstream petroleum sector. And this goes a long way to boost the financial landscape of the energy sector as a whole. On the employment landscape for the energy sector, ladies and gentlemen, local content has played a significant role in increasing Ghanaian participation in the energy sector.
And that was Deputy Minister of Energy, John Sani. Moving on to debt-related stories, economist Dr. Saad Idrisu has raised concerns about Ghana's high and rising debt levels, currently hovering around 700 billion cedis. In an interview with 3 Business, he highlighted the looming consequences of the country's high debt, noting that the country will face further debt distress if a cap is not put on government borrowing to restrict subsequent governments and allow for economic development.
If you look at our debt situation under this government, with an increase of over 500%, that is from 120 billion cedis, now our debts as a nation is sitting over 700 billion cedis. It tells you that if we continue on this trend, future government will not be able to have funds for development, because whatever funds that future government will have, it will now be used for interest payments. And that brings us to ask ourselves as a nation, is it time that we put a cap on government borrowing so that each government that comes into power, there will be a law binding on how much they could borrow? Because this government could be used as a case study on how they have raised our debts. And if as a nation, we should start looking into that direction.
And that was US-based economist Dr. Saad Idrisu making a case for putting a cap on government borrowings. In a bid to increase insurance penetration in Ghana and protect investments, particularly in the informal sector, the National Insurance Commission is implementing initiatives aimed at helping insurance companies design tailored policies for the sector. In an interview with 3 Business, Acting Commissioner Michael Kofi Ando emphasized that the regulator's efforts to engage with informal sector workers to understand their specific insurance needs is crucial. Despite the significant benefits of insurance, the country's penetration rate remains below 2%, leaving over 75% of Ghanaians, approximately 25 million people, uninsured.
But we know that in Ghana we have more people in the informal sector than the formal sector. And so to be able to grow the industry and extend coverage and penetration, there is a need to focus on the informal sector. So there are 2-pronged approaches that we are pursuing, one from the supply side and one from the demand side. So on the supply side, we are training the insurance companies to design products that are suitable for the informal sector operators. And then on the demand side, we are educating the operators in the informal sector about the risks that they run and how they can use insurance to mitigate some of those risks. The people in the informal sector alone, they don't buy a lot of insurance. Not because they don't need it, but because there's a gap.
You heard Acting Commissioner of the National Insurance Commission, NIC, Michael Kofi Ando, highlighting some steps to enroll the informal sector into the insurance sector. And that will be all for the business segment on Hot Edition with me, Bismarck Ausa. For more business stories, please log on to 3news.com. Orek Wanfofu is here with the sports. Do stay.
Hello, good evening, and welcome to the sports segment here on Hot Edition on 3FM 92.7. My name is Oreku Ampofo, and we do start off with beach soccer, where we caught up with the Golden Boot winner of the just ended Beach Soccer Africa Cup of Nations in Morocco. Now, his name is Alexander Ejay, who scored 11 goals and helped Ghana's team, the Black Sharks, to a historic 5th place in the competition.
My teammates for the outward we did there, but it was not totally 100%, but we did our best. One thing is I was having an injury before we played the qualifiers, which is we play against Cote d'Ivoire. Going to Egypt, it was a very, very tough decision for the team management and of like our team, like our teams. So it was like I was dropped. I was not part of the squad. I promised them that I will not displease them because they were like, Alex is not in the best shape, so I think we should leave him. And they didn't accept that. So I really thank them for that. So going there, I was making everything possible that I must bring something home. That is my aim. And also to qualify the team. If not even the goal king, I should qualify the team to the World Cup. But unfortunately, we couldn't do that.
That was Alexander Ejay, who finished top scorer of the just ended Africa Cup of Nations when it comes to beach soccer. But let's come to the Ghana Premier League, where in about an hour's time, Asante Kotoko would be in action for the outstanding game against Legon Cities. Now the Porcupine Warriors would be looking to return to winning ways after drawing 1-1 with Holy Stars Basake over the weekend. Legon City still remain winless in the Ghana Premier League so far and sits bottom of the table. Head coach of Asante Kotoko, Prosper Natiogum, is optimistic ahead of the game.
I think we need to go all out and make sure that we get the maximum points. These are two different teams entirely. They have a new team altogether. We also have a new team altogether. And I think that's where the difference lies. I mean, it's not like both teams are keeping to their old players where they know themselves. So all that we have to do is to make sure that we work extra hard on the field tomorrow and make sure that the few chances or the many chances that will come our way, we try and then convert them, because we need to make sure that we go home with a maximum point.
Well, that was Prosper Natiogum. Asante Kotoko face Legon Cities at 7 p.m. At the University of Ghana Sports Stadium. You can get action of that. Follow the updates on our social media handles at 3SportsGH. And then also for the under-20, the Black Satellites, they also in action at 7 p.m. when they face Nigeria. They also the under-20 team for the final of the Zone B Under-20 Championships. Both teams have automatically qualified for the Under-20 AFCON. It's now a case of bragging rights and who wins the competition. The Black Satellites, they did win their semi-finals, coming from behind to beat Ivory Coast by 2-1, and then Nigeria comfortably brushed aside Niger, winning by 3-1 as well. So it's Ghana versus Nigeria, 7 p.m. You can also get live updates of that on our social media handles at 3SportsGH. But before we go, let's do some updates from European football, where it's expected that Ruud van Nistelrooy, who has been appointed as the interim manager of Manchester United, would be in action. He would be taking charge of the team for a longer period than expected after United's negotiation with Amorim seems to have taken a longer route now, with the Portuguese coach set to stay with Sporting CP till the November international break. Multiple sources in Portugal have said that Sporting are looking for a €5 million compensation fee for Amorim's coaches to also move to Old Trafford. Although this has not been confirmed by Manchester United, it's expected that Van Nistelrooy will be in charge for the first time when Leicester City visit Old Trafford in the Carabao Cup last 16 tonight. He was placed in temporary charge after Erik ten Hag's sacking on Monday, with Manchester United currently sitting 14th when it comes to the Premier League. But as I mentioned, United face Leicester tonight in the Carabao Cup, where Ruud van Nistelrooy will take charge of the team for the first time. But that's not the only match that would be played later tonight. Brighton hosts Liverpool. Arsenal also travel to Preston United, and then Aston Villa host Crystal Palace. Newcastle face Chelsea once again, and then the late kickoff at 8:15 is a big one that sees two Premier League sides clash: Tottenham Hotspur versus Manchester City. Before we go, some disturbing news from Spain, where Valencia's Copa del Rey match against Pala Escuela has been postponed after devastating flash floods in Spain. At least 62 people have died after torrential rain in the country, with the town of Chiva near Valencia receiving more than a year's worth of rain in just about 8 hours. Valencia's away game against the sixth-tier side was to be played in Pala, located 15 miles from the Spanish capital of Madrid, on Wednesday. The match has been rescheduled to November 6th and would now be played at the same venue. The Spanish Federation did say that it's working intensively with affected clubs, with 5 matches now postponed. Second Division Levante's trip to 4th-tier Pontevedra in northwest Spain has also been pushed back to next week. Thursday's fixtures were also affected, with other matches set to be moved back as well. Several La Liga clubs, including Real Madrid and Barcelona, expressed their condolences to victims of the flood. If you want some more stories, you can check out our social media handles at 3sportsgh. Also, you can go to our website, 3news/sports, for the latest in the world of sports. My name is Ore Kwampofo, and Hot Edition continues right after this.
Your vote is your power. Go out and express this power through voting.
Election Command Center. Facts, analysis, results.
Imagine a place where voices matter, where every corner, every street, every community is a platform.
A big bus moving through Accra, carrying conversations, questions, and the pulse of the nation. This is not just another show, it's your voice on the move.
Join us as 3FM Sunrise hits the road, turning ordinary streets into platforms for extraordinary dialogue. Speak freely, listen deeply, and help shape the conversation that drives Ghana forward.
Look out for the bus and tune in exclusively on 3FM 92.7, your urban lifestyle radio.
FM 92.7.
He shouldn't answer 170 questions. He should answer only 3 questions. 3. Why is the exchange rate 17 cedis to the dollar? Question 1. Exam, he should come and write. Why has Ghana's debt risen from 120 billion to 767 billion in 8 years? Question 2, he should come and answer. Question 3, why is inflation where it is? Why did it rise to 54%? under your administration for 8 years? And then let me add 2 more. Question 4. Why did you borrow 42 billion cedis from the Bank of Ghana? Why did you borrow 42 billion cedis from the Bank of Ghana? He should come and answer those questions. We don't need 170 questions. 170, if he wants, he can answer them himself. But Ghanaians are asking him 4 questions. He should come and answer those 4 questions and explain to Ghanaians why we are where we are. The last question is, why has he run away from the economy to digitalization? He used to do big about economy. Today he can't mention economy. It's not in his vocabulary. Anytime he opens his mouth, digitalization. Come and talk about the economy. That's question 5. 5 questions. Tell him. He should come and answer them.
President Akufo-Addo, who is on a campaign tour in parts of the Bono and Ahafo regions, will not let this slide as he had this message for the flag bearer of the NDC.
Mama say on your debate ne enye china. If you say Baumia enye ni tipen. Hey sir. Onye ni class. Me to me who class people be are you Mahama Wumwa. Baumia me who class go. But the class ba ko aminim. Class ba ko aminim. Ayura Mahama Ewumu. Eye class if his time I say Fourth Republic 1993 Nkrofo enum ena Ghana fo ahye won enu nyam apegye won aba betina ebenwa kese ye kunwa kese ye president kunwa no so Nkrofo enum ba ko ede Nyankopon amane kwa amane wie mane eno friend no ba ne chen eye Euro Professor Mills Inti 4 na aka no nipa ba ko pe ena Ghana fo hwe na djuma so on se da bi owura o ade de enso ani enkoyie titsase Inti say owura Mahama also was class bia na yes a class of 1 no no was a class no na enye class a me pese Baumia eba be kasa class no the B Baumia Nyakopon emma kwan na ofro akonwa no 7 January obeto aso bio obefru review wa be ka Rollins Kufo enemy so Mahama there no 1-term president no there near no any about be amai Baumia it is a son of person it's a class of 1 or woman no enti no onto be ni Baumia entra epon so enkasa well na esonwara
That's President Akufo-Addo there. Ghana has become a sad model of democracy across the world following the destruction of independent state institutions. These are the words of John Mahama as he campaigned in the NPP stronghold of Bimbela in the northern region. A colleague, Komla Kluche, is with the campaign team there. And this is what John Mahama has been saying in Bimbela.
People outside in the world ask me, Ghana, what happened to you? Kwame Nkrumah's Ghana, what happened to you? Everybody looked up to Ghana as the model of democracy. Today, we are a bad model of democracy. Our judiciary is not independent. All our state institutions have been destroyed. People looked up to Ghana as a country that is a model of economic management. Today, our economy is in shambles. And the people who came and said that they were coming in order that our economy would be better. Today, our economy is worse. We're in debt. There is hardship in the land. Prices of goods and services are rising every day. And yet, every day, they come and tell us we should clap for them. They've done well. How can we clap for you? When cement was 24 cedis a bag, today is more than 1 million cedis. How can we clap for you? When petrol was 14 cedis a gallon, today petrol is more than 75 cedis a gallon. You remember what they said? And I remember my younger brother, Baumia. What did he say? He said, teachers are, nurses are, farmers are, and students, contractors, doctors, and everybody. I want to remind him that those people are suffering more today than in 2016.
That's John Mahalma there. Now, still live here on Campaign Trail on your Election Command Center. 38 days to Election Day, December 7th. Stay with us here across all media journal platforms. Bring you everything you need to know. The wife of the new Patriotic Party flag bearer, Haja Samira Baumia, has emphasized that the development of the North hinges on the commitment of the people to vote for her husband, as leadership for this country will bring tangible improvement to the area. She noted that the northern Ghana needs development, underscoring the importance of enhanced infrastructure, accessible healthcare, and educational facilities. At a rally in Savelugu, Haja Samira Baumia passionately urged the people to support her husband, Dr. Mahmoud Baumia, in his bid to become the next president of the Republic of Ghana.
Constituency, inshallah, Dr. Baumia is bringing 1 million digital jobs for the people of Ghana, and Savugu constituency will get its fair share of it. There's also a women's fund to support women who want to trade, and Hajia Fataya will come to Accra and bring the Savugu constituency their share of the women's fund. To support farmers, we are going to support traders, we are going to continue nursing training allowance, teacher training allowance, free education, one constituency, one ambulance, one district, one factory. We are going to move this country forward.
That's Samira Baumia there. Candidate of the opposition NDC, Professor Nana Jeno Pokwajiman, has urged communicators of the opposition party to spread the party's policies and eschew politics of insult. Addressing party supporters in the Obuasi West constituency, Professor Nana Jeno Pokwajiman advised supporters of the party to only debate on issues.
Ana yedi atem no di yedi enfa yan kosihwe ansa sahwe ama potholes no ama kwani anye niye ama nsu ameka ho ama schools ameka ho ama airport papa bi ameka ho ama habo ama ameka ho ama manfo asumanjwom na ye ya ne se akire mofra no kasa enyefe na amfata yen entenu de ena ye years nche obi a odi atam na chese wunya serious won pa de papa ye enti wo no wo de atena nchen.
That's Professor Nana Jeno Pokwajiman there. That's our end campaign trail here on your Election Command Center. It's more news on 3news.com. Make some time and visit 3news.com. On behalf of the rest of the team, thank you so much for staying with us here on Hot Edition and also on Campaign Trail. Join me at 10 p.m. on TV3 We're also going to be live on 3FM 92.7 with Ghana Tonight. My name is Alfred Akrofi Ocansey. The drive continues.